right, hello, welcome. This is Condo Spotlight. My name is Bradley Chaplick. I'm a condominium lawyer at Horlick, Levitt, Villela. We are in my backyard and on Zoom with Jonathan Jacobs. John, please introduce yourself, the great Jonathan Jacobs.
Yeah, I'm Jonathan Jacobs. I'm an ADR, Alternative Dispute Resolution practitioner. I practice as a mediator, and as well, I'm a lawyer by training. And I am the co-founder of the Canadian Cannabis Dispute Resolution Center, otherwise known as the CCDRC. And we are a team of ADR practitioners who seek to resolve all forms of cannabis-related problems and disputes that exist.
All right, that sounds great. So today we're going to talk a little bit about cannabis dispute resolution, and I thank you for joining me and on to our topic. So John, the first question we had for today was about condominium rules that prohibit cannabis smoking in condominiums. Are these rules valid?
So the short answer to that question is yes. Condominium corporations are entitled to create rules to regulate the use of cannabis in their building in a similar way that they might regulate tobacco smoking. So under the Condominium Act, which I'm just going to call the Act going forward, condo corporations can prohibit the use or production of cannabis on their property, and they can do so in several ways. They can do so by amending a declaration and making or amending a rule. So there's only been one case that's kind of come up on this topic. It was a Quebec case, LLU versus Syndicat de la Copropriété, number 7500, 7502, and 7504 Rue Saint-Girard, Montreal. Happy to give you the citation for any of your listeners out there later. But the reality is that when a corporation adopted bylaws prohibiting the use of smokable substances such as cannabis in the condos, someone challenged it, and they felt that it lacked the necessary support from other owners and it affected that person's right to use the unit as they chose and violated the rights to privacy within the home. And those arguments were ultimately rejected by the Quebec court, especially in terms of the ban on smoking tobacco and cannabis inside the units in common elements. It was something that they found to be legal and enforceable thing that a condo could do.
Okay, so we understand that condos can pass rules that prohibit cannabis smoking, and in many cases, within the last couple years, condominium corporations have elected to do so. And so now we're in the situation where we have all of these condominium corporations that have passed these rules, and they're looking to enforce because not every resident complies with the rules. So if you have a resident who's not in compliance and you have a condominium corporation looking to enforce, often the condominium corporation is hesitant to mediate because they figure that there's really nothing to mediate. They just want compliance. So why would a condominium corporation consider mediation in those circumstances where they're trying to enforce compliance with a no smoking rule?
Yeah, and it's a good question. And I think that what condominiums have to be mindful of is that if there is a disagreement between the resident who they perceive to be offending any of the rules and bylaws passed by smoking cannabis that might be disturbing neighbors, if there's a disagreement by that consumer, by that person smoking, with the condominium about its application of that declaration or bylaw or rule, most likely, there is a requirement to look at mediating a resolution of that dispute. Taking it one step back in terms of understanding if there is a disagreement, the person challenging the potential rule or bylaw that prohibits the smoking of cannabis could do so because they believe that rule does not promote the safety, security, or welfare of the owners or the property, that it does not prevent unreasonable interference with the use and enjoyment of the unit's common elements or assets of the condo, that even if there is a potential problem in terms of the consumption, there is still this duty to accommodate that particular user which may be the case if there's certain disabilities or medical needs that require them to smoke, even if there is a disturbance to other residents. And those are important factors that might create a bit of a division as to whether or not this rule needs to be followed by the person who's consuming and is disagreeing with its applicability.
Okay. But so we've got the idea that there are things to mediate. So if I understand you, you're going to mediate if there's a need to accommodate a person with a disability, and different ways that people can compromise with each other. So who should be parties to the mediation? Because often you have, in the case of a smoking dispute, you have the condominium corporation enforcing its rules, you have a resident who's smoking, and you have a complainant, someone who's brought this matter to the attention of the condominium who wants the rule enforced. Typically, it's a neighbor. Should the neighbor who's complaining be a proper party to the mediation?
Yeah, so I believe that all the parties that could be involved in this complaint should be at the table for the mediation, and that's even if there is an absence of any rules in the building regarding smoking, because there can still be the possibility that person may be causing a disturbance or a nuisance to other residents. So I would say that the parties that are involved in the complaint, ultimately that's part of the standard, is who's involved in this complaint that all of a sudden has come to the condo's attention. If it's the complaining party, the person complained about, and the condominium's agent, I would say all of those people need to be involved, regardless of if there's rules, because there is still nuisance provisions that apply to address when someone's likely causing a disturbance to other residents, even if there might not be as specific as it pertains to cannabis. So prudent for them all to be involved.
All right, and let's talk about tenants in condominium corporations, because we know that the requirement to mediate and arbitrate as opposed to going to court applies as between a condominium corporation and its unit owners, and that requirement to mediate and arbitrate does not apply as between a condominium corporation and tenants. And there's been a lot of cases stating that condominium corporations have the legal right to proceed directly to court when dealing with tenants. Even though condos have the right to proceed to court, are there any reasons why a condominium corporation would mediate before going to court if they didn't have to in a situation where they're dealing with a tenant?
I would say so. Even though they're not obligated to, it could be in everyone's benefit to do so. So the preference might be amongst all these parties involved in the dispute would be to see if mediation is better suited for the resolution of a particular type of cannabis-related dispute than going to a court action, possibly because there is still some uncertainty as to how nuisance disputes, if that's what's come about as the issue, how that will be resolved, given that it's still a novel area of law. But the parties to mediation, I think that's one of the benefits of mediation, is they're ultimately actively involved in the decision-making process. And they're all able to avoid the unpredictability of the result that might be imposed upon them by a third-party adjudicator. So, their ability to customize and expedite the mediation process really does provide a practical option to solve the problem that they're faced with expeditiously, efficiently, and through the form of transformative mediation, if that's what's being used, could lead to improved neighborly relations between everyone. And I know that there is the ability to go directly to court in this day and age. In the wake of the COVID-19 pandemic, I think there's a serious question about how quickly any matter will be solved by the courts these days, given their closure to almost everything other than the most urgent of matters. And I'm not sure that most type of cannabis disputes will be considered so urgent. They may not be, depending on the circumstances, but generally mediation can be done pretty quickly, and especially through virtual methods that everyone's using right now. So I think that those are all good reasons to consider going to mediation at this point and generally.
All right. And one of the most interesting issues I feel about cannabis disputes, which is the idea of competing accommodation. So you have, on one hand, a person who uses cannabis for medicinal purposes, and you have the complainant, who is a person who also has a medical accommodation, which is that they are allergic or sensitive to any kind of smoke. And this seems to be the most challenging scenario that a condominium corporation can be presented with, is this this battle of accommodation between two neighboring residents. And it's happened in a number of cases, some that I'm actively involved in now. How is a condominium corporation expected to respond to these types of competing accommodation claims? Like, what would you do if you were the condominium corporation faced with this seemingly impossible scenario?
And there's a good case on this that I thought the Human Rights Tribunal recently dealt with in BC, for what it's worth, where they had that exact same circumstance, where in this case, it's called the Lyra versus Strata Plan 1001, where in that case, the complainant to the Human Rights Tribunal was someone who was exposed to secondhand smoke from a neighboring resident. And they argue that the Strata Corp discriminated against her by failing to accommodate her disability, which made her vulnerable to that secondhand cannabis smoke that she was receiving from the neighbor. And ultimately, the court in that case found that the Strata Corp didn't accommodate that complainant up to the point of undue hardship, because they did not properly inquire into the degree and severity of the impacts on that person's health. They did not take measures that could have accommodated that person's disability. And to do so, they had a legal duty that, in that case, the court felt was not met. The duty to accommodate was not met, and felt that these requests for accommodation weren't dealt with in that case properly, which is something condominiums have to be mindful of. The condominium didn't collect the right sufficient amount of information to understand the nature of the accommodation. They didn't obtain expert opinions. They didn't take a lead role in investigating, and ultimately they felt that the condominium didn't approach accommodating that person with respect, because maybe they perceived that one person needed to be accommodated more than the other, and that is, I think, the challenge is how do you balance those two, and have you taken the right steps, at least as these cases might outline for you, should befall. It's to balance those two competing views that they should be accommodated based on their different medicinal needs.
Right. Well, I would take a pretty simple approach on this one. I would take the approach, just looking at the undue hardship test that we have, that undue hardship is met where your smoking is causing an allergic reaction in your neighbor. And so I would say that for a condominium corporation, looking at the undue hardship test to say, well, we're accommodating the medical cannabis smoker to the point of undue hardship. Well, undue hardship is met when your activity actually puts other people in danger. And at that point, because you've met the undue hardship threshold, which is a high threshold, but I think it's met in this type of scenario, or at least it can be if your facts support it, I think you could rightfully say to the medical cannabis user, because of the undue hardship threshold being met, we simply don't have to accommodate you. You have to find an alternative. And that's the point of undue hardship, right? Is that it's not unlimited accommodation, it's reasonable accommodation. Do you feel that type of approach, if taken by a condominium corporation, would be viewed harshly by a court?
It might. I mean, I think it kind of depends on the thoroughness of their attempt to accommodate this person. I mean, you know, for all you know, everything that can be put forward as an alternative isn't acceptable, but it is at least suggested in a way. And if that's exhausted to the point where nothing else works other than the method of consumption that's causing the problem for the other person, in that case, the person with the allergy, you know, what more could they be asked to do? Provided that, you know, as I said, kind of going through some of the precedents that we have, that they've taken the steps in a efficient and expeditious way as possible, that they've tried to understand the situation, that they've maybe obtained experts if needed to help understand the individual user's circumstances, and have taken a lead role. I mean, maybe that's all that they can do, and they've showed some form of respect to the person. That is good enough. And if still nothing can be done, well, ultimately that's where the balancing act has to be determined, and that's why we have the courts to help make these decisions. But I think so long as the condos are doing what they can, maybe that's sufficient.
All right, John, I think we're going to leave it there for today. Thank you so much for taking the time to join me and talking about cannabis disputes in condominium corporations. It's been a pleasure. So this is our Horlick, Levitt, DeLella Condo Spotlight on cannabis disputes in condominium corporations, and Mr. Jonathan Jacobs as our esteemed guest and mediator. Thank you very much, John.
Thank you for having me.
All right, take care.
Bye-bye.